So you're telling me with a straight face, that's your straight face,
Yeah.
that this building that I bought 10 years ago and depreciated it down to zero, you're telling me then when Murray died, this building got a new base of 2.2, and you're telling me I could sell it tomorrow and pay no capital gains.
That's right.
Is that what you're telling me?
That's what I'm telling you.
Hi, everybody. My name's Matt Dana, managing partner of Dana Whiting Law, and I'm here today with my other favorite partner, Mr. Trevor Whiting.
The other favorite.
The other favorite. Yeah, Todd was in here earlier,
Right.
so we had to give him a chance to think he's the favorite, right? Well, you guys know when Mr. Whiting's sitting next to me, it's going to get nerdy. There's going to be some code sections coming around,
Yeah, it might get slobbery on the table
maybe a few regulations, huh?
a little bit.
Trevor, we're going to talk about a topic today that I've never seen out there on the internet. And I know you out there playing around. Have you ever seen this topic that we're going to talk about?
No, not talked about in the way that we talk about it, for sure.
Yeah, and I'm going to call this topic for everybody the Uncle Murray provision. And it might be better to illustrate the result of what this provision can do for you before we get into the nerdy stuff of how you do it.
Right.
I think if we get into the nerdy stuff, how to do it, we might lose a lot of people. But let's tell them what it can do for them. And Trevor, I'm going to use my own father-in-law. In fact, you know that we got this provision. We named it the Uncle Murray provision because of my father-in-law, Murray Woods. And, you know, you and I did a seminar about this, and people kept asking, well, tell me about this Uncle Murray provision. And so we just named it Uncle Murray. But essentially, here's what happens is I created a Spousal Lifetime Access Trust, a SLAT, right? A lot out there on the internet about SLATs. I think they're one of the hottest estate planning tools for a husband and a wife that have a federal estate tax problem. This strategy, Trevor, we're talking about guys that their estate needs to be over 30 million. And, the more they get up there, the 50 million and the 100 million, the better the strategy works. But certainly they need to be over 30 million. But surprisingly enough, we talk about all the time these SLATs being an estate tax savings tool, which they are. They're phenomenal. And you can go look at those videos to see how they save estate taxes. But today we're going to put a different spin on it, Trevor. We're going to talk about capital gains, right?
That's right.
And Trevor, I say to people, and I know you believe it, we are experts in the estate and gift tax. And we are also experts in capital gain strategies where our clients have, give me some examples of what, where you've done this Uncle Murray provision. What type of assets does a client have that he's putting into these SLATs, we're going to get a stepped up basis inside of a SLAT. What type of asset fits real well in that?
Yeah, I've done it. I've had clients that, have appreciated stock portfolios. So they have a brokerage account with their financial advisor, and they've invested in those assets over lots of years. That those assets have appreciated significantly in value, and we can get some basis adjustment there. I've got others that have had real estate in their spousal trusts, and we get a step up there. And so it can really work for any type of appreciating asset.
A lot of exit strategies, right? Guys started these businesses and they have a closely held corporation. I'll just use an example. Maybe it's maybe the corporation's worth 30, 40 million, and their basis, what they paid for it, and after depreciation and all the write down and all the adjustments, maybe their basis is 5 million, but the corporation's worth 30, 40, 50 million. This huge built-in capital gain, right?
Right.
And so a lot of these clients, they're looking for these exit strategies. And Trevor, we have to brag a little bit on here. No one else will brag for us, but we represented 3 of the owners of the Phoenix Suns when the Suns sold a few years ago, and there were some huge capital gain issues that we wrestled with, and one of those things that we wrestled with, with them was installment sales and installment notes, where we're going to get into on another video. But sticking with the Uncle Murray, my own personal situation, so I created a SLAT, a Spousal Lifetime Access Trust, a SLAT, for my wife, Nancy. And a year later, she created a SLAT for me. And we call these reciprocal in the sense that they're very similar, but they're done at different times with different provisions. And I named in that SLAT where Nancy was the primary lifetime beneficiary. Our children and grandchildren are possible current beneficiaries and will more likely be a remainder beneficiary. And then I put my father-in-law, Murray Woods, as a beneficiary. And Murray, at the time I did this strategy, was probably about 89, 90 years old, right? And this strategy works very well when you're dealing with an older person. Life expectancy is fairly short. And the other criteria is they really don't have an estate of their own, right? Maybe, Murray at one time was a big deal, but later on in life, as happens to a lot of people, really didn't have a lot of assets. And so I made Murray a potential beneficiary. And then for the next couple of years, Nancy and I, as trustees over this trust, we helped Murray with his phone bills and his landscaping, and we helped him with different expenses that he had. And it wasn't extraordinary. Maybe 300 or 400 a month, maybe some months 500 to 1,000. And I would guess Murray passed away a year and a half ago, and I guess during that 3 or 4 year period that he was a beneficiary, maybe I paid out a total of $20,000 or $30,000. But Trevor, what happened to the so when I create this SLAT, and I put in it my law practice, I put in this building, I put in my 2 Airbnbs that I own. All of them have a very low base. When Murray Woods died, what happens to that base? And I guess it's fair to say when I take those assets and I put them into the SLAT, there's no step up in base at that time. We call that a carryover base. My base carries over to the SLAT. But when Murray Woods died, what was I able to do with that base?
Yeah, we actually get an adjustment to the base of the assets in that trust or those SLATs up to fair market value as of the date of his death. We put a provision in there that we call a power of appointment that treats it as if Murray owned those assets for income tax purposes, and for income tax purposes, because he owns it, then with his passing, we get a step up in basis on those assets. And so the building and your Airbnbs and those assets did not come out of the SLAT, and they don't go to Murray, but they're treated as if he owned them. And so that's good enough that the tax code says that when they're treated as if he owns them at the time of his death, then we get a basis adjustment.
So you're telling me with a straight face, that's your straight face,
yeah,
that this building that I bought 10 years ago and depreciated it down to zero, when Murray died, it appraised for $2.2 million. You're telling me then when Murray died, this building got a new base of 2.2, and you're telling me I can sell it tomorrow and pay no capital gains.
That's right.
Is that what you're telling me?
That's what I'm telling you.
And the law practice, my base is zero. Who knows what that's worth? Let's just say 5 million. Pick a number. A new base of 5 million. I can sell the law practice tomorrow for no capital gains.
That's right.
And so Murray died, and I got to use his exemption. Not to save estate taxes. I didn't need it for estate taxes. I'm in a green box. There is no estate tax in that green box. But you're telling me there was a way I could use his exemption to get a step up in base.
That's right. And so we put a formula into that power of appointment so that even if the assets were above his exemption amount, we only get
Let's
a
just
step
say
up
the exemption
to,
when he died was just rounded off, say it was 14 million.
yeah. So we get a step up on assets worth up to $14 million of value. And so now we've got 14 million of assets with a $14 million base. You could turn around and sell all those assets the next day, no capital gains, and all those proceeds, because they're in that green box, they're still exempt from estate taxes when you pass away or when Nancy passes away.
Now, Trevor, clients always ask, okay, where's the code section you point to do this? And you know as well as I do, this strategy isn't one code section; it's a compilation of several code sections. And here I'm going to give you a chance to slobber on the table.
There you go.
Give us these code sections where if code section A is true and code section B is true, then Uncle Murray's true. Give it to me.
Yeah, so under Code Section 2041, the IRS talks about these powers of appointment. And it says if somebody possesses at the time of their death a general power of appointment, then the assets subject to that power are subject to estate taxes when they pass away.
Whether he exercises the power or not,
It's the possession.
just holding the power,
holding the power.
makes that, we'll just call it a red asset as to him.
That's right.
That's a red asset. And technically, if you didn't have a limit on this, if you didn't say his power of appointment is only good up to this formula, up to the exemption, if that trust had 20 million in it, he would have to pay an estate tax on that 6 million above his exemption. But we're smart enough to say, Murray, I'm giving you the power to appoint. And if I believe so, Trevor, 2041 says if I give him the power to appoint to creditors of his estate, not his kids, not his favorite nieces and nephews, but creditors of his estate, just possessing that power makes that a red asset as to him.
That's right. Makes it a general power of appointment subject to Section 2041.
Okay, so there's code section 2041 is a true code section. You can look it up. General power. All right, give me another one.
So then we turn to a different section of the tax code, and then we look at Section 1014 that says that when an asset is included in somebody's estate for estate tax purposes, then that asset gets a basis adjustment at that person's death. And so, taking these two, 2041 makes the assets a red asset for Murray. They're subject to estate taxes when he passes away up to his exemption amount. And then Section 1014 says that those assets subject to that general power of appointment will get a basis adjustment up to fair market value on his date of death.
Yeah, and if you talk to tax attorneys, these two rules, 1014 and 2041, they've been around forever, and they're very well known that, powers of appointment, if they're general powers, that's a red power as to him. And we're going to talk a lot about it in other videos of these powers of appointment because, Trevor, that's a key feature that we can make a green box red or a red box green. It's just how we draft that power of appointment, correct?
Yeah, they're powerful tools, and we love them because of the flexibility that it gives us. And, but it allows that opportunity to get some tax benefits or to cause inclusion where we want inclusion so that we get a step up in basis, or to keep assets green so that they're not subject to estate taxes when somebody passes away. And we've got a lot of tools and planning we can do with those powers.
Could I have two Uncle Murrays in my document? I didn't need it. The assets in mine were below the 14 million, but let's say the client's out there he has $30 million of stock. Can he have two Uncle Murrays?
You could have two, you could have three, you could have four.
But don't get greedy here.
Don't get too greedy, right? But you could have one. And Matt, one of the places where I've used these frequently with clients where there are two is I've got several clients that they own the house that their elderly parents live in, right? And so we can move that house into a green box, into a trust, give the parents the right to live in that house for the rest of their life. They're not paying rent anyway. And so we give them we put the house into the trust. The parents have the right to live in the house. So they're receiving a very real benefit from that trust in having that right to live there. And then when they pass away, that house is subject to this general power of appointment under a formula. and we get a step up in basis on that house. If there's other assets in the trust too, we might get a step up in basis on some of those. And we get that when dad passes away, we step it up. And then if mom lives a couple more years and there's further appreciation, then she passes away, then we get another step up on the second one.
Yeah, Trevor, you know that we just finished kind of a memo on this topic that we're given to clients that embrace this Uncle Murray provision. And in that, I wrote that there's really only one risk of this strategy. And to me, the risk was Uncle Murray, and you nailed it, a true legitimate beneficiary. I mean, I know you like hanging out at the nursing home and painting toenails down there and
finding people with not a lot of assets
that have exemptions. But
yeah.
If they're a legitimate beneficiary, and we make them legitimate by writing some monthly checks, helping them out, and we also make them a legitimate, saying that if they survive, if Murray would have survived Nancy, we would have given a specific gift. So I think, Trevor, as long as they're a legitimate beneficiary, I think we're on pretty solid ground.
I think so too.
Yeah. Just if people want to search out there and they want to, check our math and check our code sections, what is this? We didn't invent this strategy, Trevor. We go to the best seminars around the country with the best of the best, working with these $100 million clients. What are these professors? Some of our favorite speakers are professors. What do they call this strategy?
Yeah, one thing that they call it is a circumscribed general power of appointment.
Yeah.
Or maybe a formula general power of appointment. So it's all tied to that general power of appointment under Section 2041. But then this concept of circumscribed or formula means that it's not necessarily going to apply to everything in the trust. For if there was the $30 million in the trust, we're going to limit it to the holder's available exemption amount.
Trevor, we're on a roll here. We're going to bring this home. And this is me. I'm getting free advice from Trevor Whiting today. So in Trump's big, beautiful tax bill, he passed some provisions about Airbnb owners. And I've been an Airbnb owner. I have a couple of Airbnbs and looking at a third. And Trevor, basically, as you know, one of the big provisions in there is you can let's say I buy an Airbnb for $1.5 million, that there's certain ways that I could write off up to $1 million of that, doing cost segregation and different things through depreciation. But historically, I couldn't take these big losses and offset it against my salary here at Dana Whiting Law. I couldn't do that. I think if it was a passive activity, and real estate's generally a passive activity, if I don't materially participate, I can only take up to $25,000 of a passive loss against my salary. But the way I read this new bill, Trevor, I could take that $1 million, I could go out and buy an Airbnb, and let's just give an example. $500,000 for the land that I can't depreciate, $1 million for the building that I can depreciate, and I can do cost segregation. If I had $1 million salary, I could take that $1 million purchase and offset against my salary. True? I know they're generally speaking, right? There's a lot of,
that's right.
I got to meet some tests.
Yep.
So, but now my basis is zero, right? But what if I had that inside of a SLAT, and can I add another Uncle Murray to this SLAT?
Sure.
I got other Uncle Murrays in my life. I can add them to this SLAT, write this down to zero. The new Uncle Murray dies. What happens to that basis?
You bump it back up to whatever the value is at that time.
This is too good to be true. Guys, come on, give us some love here. This is amazing stuff. Writing off
new cost segregation study.
Yeah.
Depreciate it again and offset your income and not only your passive income, but your active income as well, your earned income.
Yeah, phenomenal, Trevor. Thanks for your time today. I mean, people can sit out there and say, well, it's not code section, I'm not going to do it. Go ahead, don't do it. I'm just saying, I've done it. I'm very happy with it. I think it works great. But thanks for your time today.
Yeah, you're welcome.